Can you hear us, Jared?
I can now.
That's it. Okay, thank you for joining us tonight. You'll have 3 minutes. There'll be a wind-up bell at 2.5 minutes. And please just let us know which agenda item you're speaking to and whether you're for or against the recommendation in the business paper.
Okay, first, can I confirm that you can hear me clearly?
Yeah, we can.
Hello?
Thank you.
Okay, terrific.
You can start whenever you're ready.
Okay, terrific. Okay, my name is Gerard Nicol and I live on Maroomba Road in Bombay. I'm here to speak against the staff recommendation in item 9.1. At the June 25th meeting, staff recommended that the old policy be endorsed, yet Council voted unanimously to hold a workshop to decide whether change is necessary. Only Council can decide whether a policy change is needed, and the CEO can only redraft a policy if directed to do so. There is no record of any such decision or direction, and yet here we are with a brand new policy. During the June debate, Councillor Waterhouse explicitly said residents must be consulted before any new policy is put forward, and Councillor McDonald said input is essential this time. These were not aspirations, they are legal obligations. Council's own policies and New South Wales law require residents to be consulted during policy development. Despite that, residents were deliberately excluded. There is no acknowledgement of what was wrong with the old policy. It is a criminal offence to perform works on a road without formal approval. Staff admitted in 2023 that illegal maintenance had been occurring, and when Councillor Wilson asked about it, the CEO's only response was that nobody has been prosecuted, not that the law was being followed. This new draft does not address this huge legal problem. Noting that residents may apply to undertake works does not address the actual need for formal consent, nor does it acknowledge that residents can, even theoretically, be approved to repair or maintain a road. Not one other council in New South Wales has a policy that allows residents to undertake road repairs or maintenance, even with approval. The draft does not address annual inspection requirements, nor the absence of a complete public road register, which is a clear breach of the Roads Act. The draft perpetuates discrimination by continued benevolent maintenance of Crown roads, while claiming that QPRC have inadequate resources to maintain a handful of its own roads. Residents are not asking for favours. We are asking Council to follow the law and honour its own policies. Endorsing this policy tonight would do neither. Please send it back, do the consultation properly, and give the residents of this region a lawful, transparent and fair process. Thank you.
Thank you. Are we going to deal with item 9.1 first? We are. So item 9.1 is the policy review, unsealed council road policy. We have our mover as per the business paper, Councillor Wilson, and a seconder, Councillor McDonald. Councillor Wilson.
Thank you, Mayor. I appreciate there may be some discussion to come, and I might have a question within my contribution to the Director of Infrastructure Services. But let me first start by saying that I appreciated and supported the first deferral of this item, and I think the community should take courage, take note, support that there was a decent discussion had amongst councillors at the workshops, etc., and there has been some amendments to the policy. I'd also like to thank Mr. Duff, the Director of Infrastructure Services. He's done a very good job at trying to pull this complicated policy together. I'll make one comment that it is good that we are maintaining more roads. I remember when we first started, actually, councillors were in a poor financial position. We weren't grading enough roads and we weren't maintaining things. So there's a lot of conversation happening, rightfully so, around the Category 10 element, which we're now getting rid of, which is a good thing, and the unmaintained roads. But actually, we are doing more road maintenance. We're doing more kilometres, and that is because we've put resources into that. So that's a good thing. Also, want to make comment that the document wouldn't be put up if it wasn't, but I did feel like I should say that it is legally sound. As councillors, we act on advice. I've read that legal advice, and I'm confident of that. Like I said before, there's a good change, I think, to get rid of the Category 10 component, Mayor. I think that provided confusion in a way. And I do have a quick question on that, through you, Mayor, to the Director of Infrastructure Services. If this policy goes out and it's tweaked a bit, but effectively we've still got unmaintained roads and then maintained unsealed roads, could a councillor bring forward a notice of motion, or the community run a petition, or make the case to bring an unmaintained road into the maintained section? I believe so, but just want to get that confirmed.
Okay. Mr. Duff.
Thank you, and through you, Mr. Mayor. Yes, indeed, the policy has that discretion of council to review any scenario that's brought forward.
A secondary to that question, in that vein, if a community were to think we just need to quickly update this road, could they seek? I know the policy says so, but would there be a quick turnaround around that council endorsement for that road?
Mr. Duff.
Through you, Mr. Mayor, it would depend on the assessment of the road condition and the level of works required. For example, if the inspection and verification showed that there was some immediate short-term work that could be undertaken to improve its condition, then that could well be a very short turnaround. If the assessment is more detailed, requiring a lot more engineering and technical assessment and, let's say, more detailed costings, then that would take longer. So it just depends on the scenario itself.
Sorry, I've got a couple. Thank you, Mayor, on indulgence. Under this policy, if a unmaintained road had a shocking outage or there's a real issue, is there anything precluding council making an ad hoc decision to fix up a particular section, or is it going to be on the community?
Mr. Duff.
Without bringing it across to the maintained section of the policy.
Through you, Mr. Mayor. So council always has discretion to undertake road work, and that's always the case. The revised draft before you would make that allowable, permissible on unmaintained or not maintained, aka Category 10 roads, without being in conflict with a standing policy. So I would say council always has the discretion, or can make a resolution to undertake road work on any of its network. What the policy aims to do is to avoid conflict where it may actually say thou shalt not do. Thank you.
And just thank you for those questions. And finally, I think this is a difficult problem for rural councils across the whole of New South Wales. We're not Robinson Crusoe here. We are amongst other shires that are trying to balance the resources they have, the rates they can collect, to trying to find and deal with a lot of these type of roads. So appreciate if this does get out to public consultation, that is public consultation, and I look forward to that process. Thank you.
Thank you. Councillor McDonald.
Thank you, Mayor. Can I first start by thanking the residents who, over the history of this discussion, have made their views clear to myself, to colleagues, and to council staff. And I think, were it not for residents who sat in this chamber and gave their testimony to the effect of the previous policy, which proposed a continuation of the Category 10 road structure, I don't think we'd be here. It was at that meeting where, and I should just call out I think they were the Canary in the Coal Mine Road, being Brick Kiln Lane, which I know I visited, and other councillors, Waterhouse and Grundy, I certainly know that both have visited and understood that impact of that previous policy. And this draft policy looks nothing like that to me, because it effectively removes that policy shackle on council which says you're not to touch it, an unmaintained road. Now, when that was discussed in this chamber, when in the form of the previous policy, I raised concerns about the legality of that decision or that policy. And council has sought legal advice on those matters, and without waiving the legal professional privilege which is afforded to council in providing that advice, I can tell you that that I am satisfied that the concerns which I had with respect to the legality of the previous policy have been addressed through this proposal. That the discretion that ought be applied to council under the Roads Act, or does exist for council to undertake works per the Roads Act, is addressed, and that whilst the extent to which all of these matters are justiciable by an individual, I think certainly it has been confirmed by that legal advice that this policy puts council in a better legal position to deal with these matters. But really, what this policy does in its current form, aside from being subject to 28 days worth of consideration, is provide more latitude to council, and I think that is a good thing. It not only provides guidance and greater latitude to staff, but it also, within the policy, provides greater latitude and consideration to this chamber. And we see that within the considerations. May also consider, doesn't mean must or can only, but it may also consider, we go down to that old catch-all down at the bottom, which says other considerations at the discretion of council, and it goes to Councillor Wilson's point that someone may bring a notice of motion forward, or that council may consider matters beyond the strictness of the matters for consideration per the draft policy. I think my colleagues having been part of this discussion, I've really appreciated the opportunity to interrogate it, and I accept the real goodwill of many colleagues, regardless of where people may fall on the decision on this matter as to whether to put this out for public consultation. I am comfortable that the issues which I had addressed in the early consideration of this matter have been addressed, and would urge, through you, Mayor, other colleagues to form that view.
Thank you, Councillor McDonald. Councillor Waterhouse.
Thank you, Mr Mayor. I'd like to speak against this motion, and in doing so, I'd like to put forward an amendment. The reason it would be an amendment is because it does not contradict the spirit of the existing one, but it slows it down. It's up on the wall now.
You want to speak to the item first, or put your amendment?
I'll speak to them and then put the amendment, if I may, if that's acceptable. Thanks, Mr Mayor, and thanks everybody.
Point of order. Can I just clarify, if Councillor Waterhouse speaks to the recommendation and then puts his amendment, at what point does he get to speak to the amendment, or does he forfeit that? So
he does have the opportunity to speak to the motions in front of us, and also to his amendment. So it's really up to him. Okay. But let's let him speak to this item and then move his amendment, and we'll go from there. Councillor Waterhouse.
Okay, I'll keep my comments on this particular motion short. I don't think the policy is ready for our endorsement, and I'm a bit unhappy about how it's transpired. We've had 2 workshops with seeking councillor suggestions. When I first moved the motion, as was mentioned actually by the member of the public when we opened this meeting, that I said, and everyone agreed, that it should be pulled out, looked at again, taken to the community, and then brought back in a revised form. And it has not been to the community yet. The idea of that is so the community can contribute to the development of the policy, not looked at the policy after it is relatively set. That hasn't happened.
It's not been offered to the community for their suggestions either in a meeting or in writing. My concern is that this is a clear and unambiguous policy. It's really important that that's the case, and I shall refrain from anything else until I'm putting my amendment.
Okay, so let us know your amendment, Councillor Waterhouse.
Okay, the amendment's up on the wall. I'll read it if you wish me to. That Council defer consideration of the draft Unsealed Council Road Policy, dated this month, that it does not proceed to public exhibition at this time, and that it be revised further, incorporating councillor and public suggestions, and brought back to Council following appropriate councillor workshops and community engagement.
Okay, do we have a seconder of Councillor Waterhouse's amendment? Councillor Grundy, thank you. Councillor Waterhouse.
Thanks very much. I don't believe the draft policy it currently stands, despite the fact it may well be legally sound, I'm not absolutely convinced that it is actually defendable. I'm not convinced that it's completely ethical and equitable, fair and equitable, and I'm not convinced that it's capable of achieving its stated objectives in actual practice. The definitions need to be refined and used, and the uses of those definitions within the policy need to be have greater clarity and alignment with the uses of the terms in the legal advice already supplied and as established in common usage. The policy cannot redefine the English language as used in common parlance. This especially refers to the terms maintenance, maintained and asset condition. The terms being used need to be consistent and intimately aligned with the Roads Act 1993. Usage of the words, how that is done there, and in particular, most importantly, in common use by the public. I would suggest, at the very least, replacing the words maintained and unmaintained with something like scheduled maintenance roads and non-scheduled maintenance road. They be a more appropriate use of the term. It may be useful or perhaps necessary to clearly define maintenance as a proactive kind of action and repair as a reactive kind of thing, and then separately to that, upgrade or improvements. They all need to be defined in this policy and be really clear as to that's what's meant. The constant use of the word may in both definitions and in the policy is of considerable concern, as I can assure you they will be seen as weasel words designed to supply excuses to not do something. Council discretion based on inspection and funding sources is quite clear in the policy without using that word. It's absolutely unnecessary. It's really clear that it's got council discretion as to whether something will happen or not and whether we can afford it or not. I believe that the minimum construction standards need to be revised to more accurately reflect actual asset condition, away from some sort of aspirational, potentially unachievable description to a more accurate one. Maintain the higher standards for new roads in new subdivisions, certainly, but revert to the pre-existing standard from before the last change, which I think was dated probably 2018, but I'm not certain of the date when it was changed, but it's not all that long ago. It was changed from 4 metres wide to 6 metres wide, and from 100 millimetres thick to 125 millimetres thick. Alternatively, you could have two standards, one for future roads and one acknowledging the existing conditions of most categories. Connect these standards to the asset condition definition, which also needs modifying to clarify the fact that this policy is only referring to intended and not actual asset condition. The definition should have the word intended as part of the concept because that's what you use in the rest of the policy. It's particularly important in the second dot point on page 7 under the heading transfer from unmaintained to maintained roads, etc., where it refers to the council minimum standard being met before council takes control of a road. This is absolutely unrealistic and I would suggest inequitable. The old standard of 4 metres, or perhaps an improved 4.5 metres, would be far more appropriate in this circumstance. I have been out with a tape measure. I have measured roads. There are hardly any roads in our network that are 6 metres wide now. We already maintain them at 4 and 4.5 and 5 metres, and possibly even smaller. To confirm that, in compliance with Section 53 of the Roads Act, Council holds and maintains an accurate register of all roads for which it is the roads authority. This should include a description of the road's asset condition as based on the standards being referred to or described in this policy. My understanding of that list is that it's a work in progress right now. We also must ensure that further consultation with affected and interested residents is undertaken in accordance with our own community engagement strategy and policy development and review policy, which requires that residents be consulted at, in capital letters, the most influential stage of the policy process, not after key decisions have been made, like this one now. I suggest that written submissions would be far more efficacious than a public meeting. That's the background of this amendment. I believe we need a longer, harder look at the wording of this document. Thank you.
Thank you, Councillor Waterhouse. Councillor Grundy.
Mr Mayor, am I able to reserve at this point?
Absolutely.
Thank you.
Okay, further discussion on the amendment. Councillor Willis.
Thank you. I had a question for Mr Duff. In the material that was provided to councillors as part of the workshops, there were examples of how other regional and rural councils manage this matter. And I wondered if he could confirm that what's proposed here in the draft policy is consistent with, I think it was half a dozen New South Wales councils in similar situation in terms of their rural roads network. And how they address the matter, how they approach the matter.
Mr Duff.
Thank you, and through you, Mr Mayor. The background work that staff did in the review process were only able to find council policies of a similar council, I should say, with a significant rural network, more alike to the current policy, which distances as in precludes work on, there's a number of different words, definitions that are used. Sometimes it's called unmaintained, sometimes it's called unformed, unimproved, but the common position of the councils, and there were 4 that were provided through during the workshop period, were that for reasons possibly of why the current policy was set as it is, as a measure of financial risk mitigation or risk management. I'm not aware of any New South Wales councils who are stepping towards the position of the revised draft before you, but that's not to say that that isn't happening. It certainly seems to be more like our current policy, which doesn't commit to any investment on unmaintained roads.
Thank you. So from what you've just told us, the draft policy before us is an improvement, and certainly an improvement on what those, I think you said 4 similar councils do for their unsealed roads.
Is that a statement or a question?
It's a rhetorical.
It's an observation. What did Tony Jones used to say? I've forgotten. Yeah.
Okay, further discussion on the amendment, councillors? Councillor Wilson?
Just a question, Mayor. No commentary at this stage. Just Councillor Waterhouse. I'm not trying to verbal Councillor Waterhouse at all. Just interested in the Director of Infrastructure Services commentary around the 4 to 6 metres component. It was sort of like we're setting the standard. Are we setting the standard, but we're just, letting other little roads are a bit narrower go, or how does that fit? I was interested in that particular component because Councillor Waterhouse was focused on that. So yeah,
Mr Duff.
Thank you. Through you, Mr Mayor. The revised draft policy at clause or section 5.1, which is the minimum construction standards, it really is in context of adding new road to our maintained road network, and so that covers new additional roads, and also the transfer of any roads from unmaintained to maintained. The information we have with regard to the previous Palarang Council and its minimum construction standards do indicate, indeed, as Councillor Waterhouse indicated, that they were narrower, so 4 metres instead of the 6 metres, and the gravel depth was less at 100 millimetres instead of 125 millimetres. Now, the reason for the change circa 7 years ago was to provide a more best practice engineering standard, and the benefit of that long term is the ongoing maintenance costs when you have such a construction is lower for maintenance costs going forward. So I understand the reasons for the change from the previous settings to the what are the current settings actually. That's been moved straight into the revised draft, and it's only intended to be in this revised draft for the purposes of when new road is added to the maintained network, and not intended to be retrospective, to actually go back and relitigate roads that are already maintained but don't meet the minimum construction standard. That's not the purpose for that section being in this revised draft.
Thank you, Mayor. That definitely answers my question. And just my quick contribution on the amendment, I won't be supporting it, but I just wanted to thank Councillor Waterhouse for bringing this forward and really leading the charge in pressing and pushing for a better outcome.
Thank you, Councillor Wilson. Is there further discussion? Councillor Preston?
Thank you. I also won't be supporting the amendment tonight, and that's not because I don't have a great deal of sympathy with what Councillor Waterhouse is saying, but almost precisely because of the information that Councillor Waterhouse has provided, and the depth of detail and the technicalities that are involved with this. What the original motion that was before us set out to do was ask for Council's endorsement to put the policy out for further consultation. So we are, in fact, going, should this amendment fail, we go back to the original motion. What we are doing is the consultation process. We have, as one of the tenets of representative democracy, we have got to ourselves to a point where we have something that we can consult upon. If we were to try and create policy for Queanbeyan Palerang Regional Council through a committee of the whole, we would never get to anywhere. So we need to have a starting point. What we have got here, as other councillors have pointed out, is a legally sound, workable starting point for consultations, and that is where we should go from here. We cannot keep kicking this can down the road. We actually have to make some decisions, and that is our role in a representative democracy.
Thank you, Councillor Preston. Councillor Broadbent.
Thanks. I won't be supporting this motion either. But I just wanted to say a quick note, I guess, in regards to the community engagement. I would be interested in, I guess, having a sidebar discussion at some point as to how, if this is something that I guess Councillor Waterhouse feels important as part of the process of community engagement, it would be a great thing to look at the policy on how we do engagement and actually think bigger picture at how we can make this a process rather than, I guess, ad hoc in this case. But I do agree with Councillor Preston. We are in a situation where, you know, we're elected individuals that represent pockets of our community, and I'm sure, as you already have done, Councillor Waterhouse, you've spent a fair bit of time talking to people that care about this policy, and that is exactly the community consultation that's important as per, I guess, the whole idea of local government, right? Is we all spend our time talking to the community, and that's where some of the consultation comes through. But yeah, I guess, yeah, I thank you for your time, but yeah, I won't be supporting this.
Thank you, Councillor Broadbent. Is there further discussion on the amendment? Councillor Grundy.
Thank you, Mr. Mayor. Look, I would hope that my colleagues don't quite yet form a view on which way they're going to vote. Not until they hear what I have to say anyway. But look, I'm very happy to support this amendment, and that's because I believe that it is sound. It is sound because the draft policy that is before us is I have problems with it. I have a problem that it doesn't tick the box for duty of care and social justice. It doesn't tick the box for financial risk accuracy, and that's a big pillar. It doesn't tick that box. It doesn't tick the box for legal soundness. It doesn't tick the box for community input. So I'll start with community input. Now, our community engagement strategy says, and I quote, engaging, not consulting, engaging with the community will bring the best results. Going to public exhibition, quote, going to public exhibition is not engaging, it's consulting, and it's consulting on an already endorsed document. So I'll leave that for you to consider. When we look at financial risk accuracy of this draft policy, think about this. Unmaintained roads list currently, we don't know. Last year when I asked about it, I was given a 32-kilometre figure. Now it's up to, I think it was 219 odd, but there's a figure of also 1,900 kilometres being floated around, which could include things like state forest roads, fire tracks, crown roads, until proven otherwise. So what I'm trying to say is we don't actually know what we're dealing with here, so we can't put any financial risk with accuracy on what we're dealing with here. Legally sound, pretty important. The document regularly talks about whether it will investigate and verify the condition of unmaintained roads. Now, Section 45 of the Civil Liabilities Act for New South Wales provides special non-feasance protection for road authorities like councils, meaning they are not liable for harm arising from their failure to carry out roadworks unless they have actual knowledge of the risk or hazard. This aims to balance the public's expectation of road safety with the financial implications of holding authorities like councils to an unreasonable standard. Now that sounds very fair. However, in practical terms, if a road authority fails to address a known risk, they may not rely on this defence to avoid liability. I'm not making this stuff up. We do not have legal robustness with this. Section 42 of the Civil Liabilities Act in New South Wales provides defences for public authorities like councils in negligence claims, enabling them to possibly avoid liability if they can demonstrate their conduct was reasonable, given their limited resources. Well, as I've pointed out, we don't have a complete and accurate list of unmaintained roads. How on earth do we have an accurate assessment of what it's going to cost us possibly to maintain them? So therefore, we can't rely on that as a defence either. There's a lot more work that needs to be done here. In finalising my comments, I did visit Brickkiln Road on Monday with my two-wheel drive car. Now, I got about halfway along and I couldn't go any further because it was impassable. I was fearful I was going to bottom out on the car. Now, there were potholes everywhere. There was an exposed concrete pipe. There were rocks protruding. There was no mobile coverage. In fact, in essence, it was impassable. So my experience in coming away from that road, and there was nowhere I could even turn around, so I had to reverse very carefully and with some fear that I'd be stuck, I must add. I came away with a very strong feeling of being ashamed as a councillor. We are allowing this draft policy to go out to public exhibition when it doesn't address these fundamental matters. And we're leaving these people who have paid occupancy certificate money, they have paid, some of them previously, subdivision costs, and they are currently paying thousands of dollars in rates, and they don't even get a road that is fit for purpose to their gate. Thank you.
Thank you, Councillor Grundy. I was just going to ask a couple of questions first before I go to you, Councillor McDonald. So we just heard from Councillor Grundy regarding the legal robustness of the policy. Can we get comment on staff relating to that? Mr. Duff?
Thank you, and through you, Mr. Mayor. Indeed, the legal review really considered two matters. One being that whether or not the policy is in accord or frustrates legislation, in particular the Roads Act 1993. Their opinion is that it does not. Also, with respect to the civil liability risk mitigation of claims in negligence, it's also the opinion that it's satisfied, and in most it's because of the discretion that council will have on a case-by-case, merit-based assessment, which is really the pivotal shift of the revised draft versus the current policy on those so-called unmaintained or Category 10 type roads.
Thank you. I have three questions. This is the second one. So I had a comment then about the list of unmaintained roads. Got a comment from you, Mr. Duff, on where we're up to with that process?
Yes, thank you, Mr. Mayor. It is correct to say there's some uncertainty about the quantum of unmaintained roads, and whilst that might seem logical because we haven't been maintaining, I also wanted to raise that there's a definition and context here around what is a road, and in particular public road by definition, and then even as we get to council roads, we then have maintained and unmaintained, and council has recently published what I'll call a progressive or a partial list, and this is a list of named, known, unmaintained roads. And it's important to have those prefixes because this is the progressive nature of the data that council is working on, certainly staff. We currently know and have names for 220 kilometres of road. There's 96 roads to make that amount. We also have unnamed, known, unmaintained roads. Bear with me, please. 77 kilometres or 105 roads. So in a nutshell, we have 300 kilometres of known unmaintained roads, but there is also the unknown unmaintained roads, which is really the balance of our whole LGA council road, which are those public roads conferred to council as the roads authority under the Roads Act. So that's why there's a whole myriad of numbers, and it's council's staff's task now to work through that to get more certainty. But what we're sure about is that there is work to do on the quality, accuracy and completeness of the asset information relating to roads.
Thank you. My last question, we've had a lot of talk about Brook Kiln Lane in particular, and we received a written submission about it where the specific request was that the road be reclassified and maintained by council. Can we talk about the impact of the new policy specifically on the potential for council to do something about Brook Kiln Lane?
Yeah, thank you, and through you, Mr. Mayor. Indeed, the revised draft policy allows for the inspection, verification of the condition, the hazard identification, risk assessment, scoping of works in order to address damage, repair, impediment of any kind, and to report the estimated costs and timeframes for consideration in terms of short-term work. And again, whilst the revised draft policy allows for that, also council can resolve to do that anyway, as mentioned before. It just now would be in accord with the policy settings and with respect to Brook Kiln Lane, and on the advice of the legal review that we've had, that's exactly the process that staff have commenced.
Thank you. All right, I will speak just quickly, then I go to you, Councillor McDonald. So very quickly, I'm on the same page as Councillor Preston and Councillor Broadbent. I do empathise with Councillor Waterhouse and his approach. I think we've got the bones of a much improved policy in front of us. I think we're all on the same page about where we want to land eventually with this. It's more of a case of how we're going to get there. I think we do need to put it out on exhibition, need to get that further feedback and have feedback from councillors and put there. And if we need to make more changes, then we will. But I think kicking the can down the road by not going out on exhibition tonight is not an option. So I will be not supporting the amendment, but I will be supporting the original motion. Councillor McDonald.
Thanks, Mayor. I just, through you, Mayor, want to address my remarks in respect to the amendment to my colleagues Waterhouse and Grundy, who have done a lot of thinking, and I acknowledged them previously on this. But there's a lot of issues that come before council where I have to consider making perfect the enemy of the good, and it's not a way we can do policy and serve our community, because we ultimately, others have used other metaphors, but we ultimately become stagnant and don't do anything. Now, it's been talked about the effect of public consultation and the 28 days that the public will have to proffer amendments, solutions, suggestions to the draft policy. And can I remind colleagues, through you, Mayor, what happened when a policy was put forward and put out to the public, which asked them their views with respect to wood fire burning in our region. Not only was the public consultation overwhelming, the policy did not proceed. So I don't expect that this process, which should the principal motion be successful, is lip service to our community. We could do this every time. For every policy, we could indeed, on Councillor Preston's interjection, we do with respect to the public showing of our policies, and that's a good thing, because it does, and I've been convinced recently, provide that real opportunity for council to take on board that feedback. Now, Mr. Duff has provided, I think, what is, and through our legal counsel, provided information to this chamber, which certainly makes me comfortable, Mayor, and I would argue should address some of those concerns. Obviously, the elephant, which we are attempting to eat bite at a time, through Mr. Duff's Donald Rumsfeld-esque known unknowns and all this about the future of or the quantum of these roads is of concern, but that work is underway, and it is work we ultimately will have to undertake as a council, and we will consider that at due time. But with respect to that canary in the coal mine, as I said, Brickkiln Lane, I am satisfied that this policy puts us in a far better position and therefore will not support an amendment to defer this any further.
Thank you. Is there further discussion on the amendment before I ask Councillor Waterhouse to sum up? You have a question, Councillor Grundy?
Thank you, Mr. Mayor. I do have a question. Is it not true that the legal advice that is spoken about here by my colleagues is in fact advice relating to the current policy and not to the draft policy?
Mr. Duff?
Through you, Mr Mayor, the legal advice behind the revised draft before you is exactly that. There was previous advice about the current policy, and I would say that one relates to the other, but the information about the assurance provided in terms of the legality and in particular about in accord and not frustrating legislation and the risk mitigation improvements with respect to civil liability are precisely to do with the revised draft included in this report.
So, Mr Mayor, where is that advice? I haven't seen it.
So I just want to confirm, so all councillors were sent updated legal advice about 3:30 this afternoon that you may not have received. So
I haven't seen it.
That's what Mr Duff's is referring to.
So
Okay.
I was in transit at that point, but which is a bit,
Okay.
it's
Do you
a bit
have a
disappointing.
further question?
In future, can councillors
Do you have
be
a
given a
question
bit more
relating? Do you have a
time?
question relating to what we're discussing right now? If not, we're going to go to Councillor Waterhouse to sum up debate on his amendment.
Thanks, Mr Mayor. Councillor Grundy, I have a hard copy of that which arrived when I was in transit as well. If I could pass it over, she might have a chance to have a quick look at it. It's a bit late now, correct. I think there's a couple of problems with what we've got here. We had a workshop last Wednesday on this matter, and sadly only 4 councillors were in attendance. So there's quite a few of us that haven't heard the 2.5 hours of discussion that we had on that night regarding that. And I was quite surprised that the policy then arrived the next day in our papers, because I was expecting it to undergo further work, because we spent a lot of time talking about nitty-gritty stuff, much of which I raised earlier. If this amendment's knocked back, then it's going to go out in a very raw state. There's misuse of the English language in it. There's inappropriately defined terms. You can't redefine English words. They're already defined. If you're going to use asset condition as a word and then only have intended attached to that, then that's what should appear in the definitions. This notion of maintained and non-maintained, everything that's mentioned in the unmaintained section on 3.10 says it will not have planned roadwork routinely carried out, however, may have reactive roadwork undertaken. That's maintenance. That's what maintenance means. So that actually contradicts itself. Within this document, there are self-contradictory statements and misuse of the English language. And although a couple of folks have mentioned this notion of changing the minimum construction standards, I think it really needs a serious reworking. If this amendment doesn't get up, I can assure you that I will be writing a submission as a member of the public, because it really does need a good shake-up. This isn't as good as we've produced in the past, folks. We've got some really good, solid policy that exists because it's such a rigorous process, but this one isn't as good as it should be. And that's I recommend the amendment to you.
Okay, Councillors, going to put the amendment. All in favour of the amendment: Councillor Grundy, Councillor Swiker, Councillor Waterhouse, and against Councillor Broadbent, Councillor Livermore, Councillor McDonald, Councillor Preston, Councillor Taskowski, Councillor Willis, Councillor Wilson, Councillor Winchester. I declare it lost. So we go back to the original motion. Is there further discussion on the motion? Councillor, or you're going to sum up debate? Councillor Will, I just want to make a very brief comment on the provision of the legal advice. It's my understanding that at the briefing last night, some was specifically requested and it was provided today. So it was asked for last night and provided by 3 o'clock this afternoon. So those saying it's a bit late, it's purely off the back of something that was asked for about 6 o'clock last night. Councillor Wilson.
Thank you, Mayor, and I do appreciate you picking up that point, because just in summing up, I do want to give confidence that obviously Council gets advice, that advice informs policy, and we take that advice on. But I just wanted to briefly sum up. I was remiss of me not to thank, as Councillor McDonald did, residents and ratepayers that have spent a lot of time and put a lot of effort in making submissions, and I appreciate that process will continue. So thank you, Mayor.
Thank you. We'll put the motion. All those in favour Councillor Broadbent, Councillor Livermore, Councillor McDonald, Councillor Preston, Councillor Schweikert, Councillor Taskowski, Councillor Willis, Councillor Wilson, Councillor Winchester, and against Councillor Grundy and Councillor Waterhouse. I declare it carried.